Bismillah ar-Rahman ar-Rahim. In this sitting, we will discuss what is crime, what are the objects of criminal administration of justice, how criminal administration of justice is dispensed, and what are the theories of the punishment. So first of all, let us see what is crime before discussing uh, the criminal administration of justice. Crime is an act which violates the public rights or the rights of the society at large. And the object of the criminal administration of justice is to punish the wrongdoer or punish the criminal in order to prevent the repetition of the crime as well as in order to deter the rest of the society, because crime is a forbidden act which is done against the society at large. That is why the state becomes a party itself whenever there is a commission of crime or offense. So, now when the crime is committed, what is the procedure which is provided by the criminal law? What agreed person has to do against whom the crime has been committed? So, as we have discussed in detail the steps of civil procedure, now we will discuss the steps of the criminal procedure in order. First of all, the first and foremost step which initiate the mechanism of criminal administration of justice is the FIR, first information report. Under section 154, you must be familiar with it, an FIR is lodged. What is FIR? FIR is basically a criminal report which is filed either by the aggrieved person or any other person who is well acquainted with the commission of the crime in the concerned police station to the station house officer against the commission of cognizable offense. So the conditionality of filing the FIR is the commission of a cognizable offense. Otherwise, it will not be entertained. So, the cognizable offense is an offense in which police officer can arrest a person without warrant. Warrant is not needed. Police can go and arrest him straight away without obtaining the warrant. So FIR is basically an application in which you mention the commission of the crime, the place of occurrence of the crime, and all the details and facts, and dubious persons, alleged persons who have been involved in it. So this FIR is filed under section 154. The second step of criminal procedure is the second step of the criminal procedure is this: the investigation. Under section 2, subsection E or H of the criminal procedure code, investigation is basically the collection of evidence conducted by IO, investigating officer. I repeat it again. Investigation is the collection of evidence by the investigating officer properly designated to investigate on that particular case. Investigation is basically the evidence, as I told you earlier, that evidence is just dispelling the obvious. The act has been done. The means which have been used for the commission of that act, these means, the proof of those means are very much there at the place of occurrence. So a good investigating officer must reach the place of occurrence as early as possible so that the evidence may not be disappeared. Evidence must be located at the first instance. So, whatever he collects, whatever he gathers to substantiate the allegations in the FIR or to negate the FIR, as the case may be, he will find it and he will present it before the court of law. So, the second step is investigation. Third step, third step of criminal procedure is filing of challan. Fourth step, which is very much important, is the framing of charge. Now, under section, first let me say that investigation is carried out under section 155 subsection 2 of the CRPC. Now, charge is framed under section 222 of CRPC. What is charge? Charge is basically uh, whenever uh, the case is presented before the magistrate or session court, accused is asked accused is asked, do you plead guilty? The allegation made to you in FIR or allegation has been collected, or the evidence has been collected, do you plead guilty? If he says yes I do, then the case is closed, he will be punished accordingly. But if he says no, I don't plead guilty, then the case will be started and charge will be framed. Charge is the alternative word of English which is called indictment. In indictment, it is basically the formal accusation against the accused. Formal accusation means that in the presence of the court, the allegations made against the accused are pronounced in front of him, and he will be given the proper opportunity to defend himself if he has committed it or not. He will be provided attorney as well. This is his constitutional right, and then he will defend himself. If he wants to defend himself by himself, he can do it, but then he will have to sworn by oath that he will be accountable and he will not present an excuse that he was not given the learned counsel. So, after the framing of charge, there comes again the stage of arguments of the lawyers, and arguments of the lawyers will be three some. As I told you in detail, the examination in chief, cross examination, and re examination, same rules will be applied here. Why same rules will be applied here? Because evidence is a substantive law as well as a procedural law, and it is applicable at the same time in criminal proceedings as well as in civil proceedings. This is the beauty of the Evidence Act or Kanun Shahadat. It is applicable simultaneously on civil and criminal matters. So after the uh, arguments, judgment will be pronounced. That judgment is exactly the same which I have just mentioned in the steps of civil procedure, that it is basically the comprehensive decision of the judge in which he compile each and every day of hearing